that was subsequently allowed. Thereafter, FO was filed by the state, which has been dismissed. After dismissal of the FO, review has been filed, my lord. In the meantime, in the execution proceeding, now the education tribunal is proceeding and fixed it to 18 to attach the salary of the secretary, my lord. I pray any day, my lord.
That is, if execution proceeding is there, review, say review, how the review will solve.
Review in FO, in dismissal of the FO, we have filed it.
On merit, it might have been dismissed.
My lord. You know, a review is pending.
Review, you have very less scope in review. Very less scope in review.
What a date, may kindly please, any date.
We'll see, give it data. Give it data. Yes.
My pardon to mention your listed before vacation. Vigilance council has typed. Your lordship, please to
let us regulate it because this is the first day. How do I know? The vigilance council. Give the memos, we'll see. Let us regulate it. Let us go systematically. Otherwise, again, it will be messed up. Everything will be messed up.
Because of interim.
Whatever, every case has a story.
Yes.
Every case has some story or the other.
Please to fix on.
We'll see. I'll just see.
I mean, pardon me, Lord. This is a matter of criminal miscase where the accounts of the self-help group has been freezed. Earlier it was in the list, but has not reached on that day.
Give the memo.
Okay.
As practical as possible, we will go by the, serially we will
That is
try to
2022.
Unless it is very pressing urgency, there is, I don't think.
2022, my lord.
We'll see.
Pardon to make a mention, Lordship. Earlier, this matter, criminal appeal number 525 of 2015 was in the weekly list before the vacation, but inadvertently it was not taken. Actually, what happened? The
weekly list not able to take what up.
I pray your Lordship, any specific dates so mentioned that can be taken up.
Including the weekly list, yes. Yes.
Mention item number 1,
Big
9.
pattern.
Yes.
Item number 2.
2, what do you want?
On behalf of the press, on the taken up next week.
Not next week. March.
Also item 4.
4 also, March.
Item 7, my lord.
See, fresh matters, these are pending. I am listing it to get it disposed of. There must be nothing in this matter. Put it in April 1st. Yes.
My lord, item 7, my lord. On behalf of Mr. Mohanty, my lord, has some personal difficulties.
April.
Item 9, my lord. This is the fresh matter, my lord. It is filed in the month of September. I will take inspection, my lord.
Those who are asking adjournment, I am sure that there is nothing in the matter.
No, my lord, it is there, my lord. I will take
keep
instruction.
it pending.
I will take instruction because it was filed in September, my lord.
April.
Month of February, your lord.
April. I will tell, I'll put it in the after vacation, July. I'm trying to get it listed.
In the past, my lord.
If you speak more than July. Fresh matters, matters are pending. I'm trying to adjust every matter and you people are asking adjournment.
This side also, my lord, some problems are there, my lord.
April. Fresh matter, those who are asking for adjournment, put it in April.
Item 10 to 23.
Yes.
My lord. 13, my lord.
13. Same. April.
My lord.
Health problem.
Short date, my lord.
Sorry? You are appearing.
My lord, short date, my lord. I will.
They have a different form. Give it.
Item 24 to 35.
Yes. No, there is not.
Item 1.
Yes, sir.
Passing of the criminal proceeding on the ground of compromise, millers. I have.
What is the offence, sir?
420 and other offences, millers.
Okay.
And I have implemented the informant as a party, millers.
Why don't you bring him?
Millers are fixed. They will have. What a date again? So, no. See.
No, move in. I have to take instruction because he has stated several persons that they have been.
I'll simply issue notice. Let us see. Let him issue notice. Mr. Jenna accept notice for the notice. Lease the matter also. Okay. And you bring him.
Lord, see what is 15.
Bring him.
Okay.
Yes.
Item 3.
Lordship, I'm standing on behalf of Sujan and Biswal. Lordship, I'm for petitioner. Lordship, the fact of the case is the petitioner is challenging, Lordship, the petitioner is challenging the order day cognizance of 22nd November to.
Here he is to implement the Union of India's party because this is a case RPF, this case instituted by the RPF.
Counsel for the petitioner seeks to among the memo parties by including respondent, release the matter. Yes.
Item 5.
May I please, Your Lordship? My Lordship, it's a matter of quashing of order of NBW.
Bail.
Yes, my Lordship. My Lordship, offenses under section 379.
You are on bail? You are on bail?
2005, my Lordship.
Yes. 1
Twenty-
minute. Read the.
21 2005 bail granted, 26 2024 MD.
Okay, 500. Yes.
Okay.
Yes.
Item
Same year. Give the dates. Give the dates.
Private case.
Item 6.
Private case.
Around the sir versus Asaf Shetty.
Or just see.
State is known.
Item 6, na? Pass over, huh? Yes.
Item 8.
The order passed in a petition on section 130 on section 143A, the land court below, directed to pay compensation. The checks are given as advance security, and all the dues has been cleared with the opposite party law. But after some dissensions arose between the parties, and we have this false statement law. So trial is necessary. Before trial,
The trial will be going on. What is the problem? 43 is you have to pay interim compensation.
he's not.
What is the check amount? What is the check amount?
4 lakhs in law.
4 lakhs.
4 lakhs.
20% the court has directed.
80,000 directed. My pray. This case is of the year 2022, my lord, and he is not taking steps to adduce evidence, my lord. They are taking time and a file.
What I'll do is that you pay 10%, I'll expedite the trial.
Yeah.
Okay. 10% then petitioner is against by the order dated. You are the accused?
I'm the okay.
Yes. Order dated 25/7/2024, passed by Lieutenant CMFC Barville in ICC case number 37 of 2022, initiated by the opposite party against the petitioner for alleged commissioner for offense punishable under section 138. By the impugn order, the court below has directed the petitioner to deposit 20% of the check amount as a interim compensation, age contemplation under section 143 capital A of the petitioner is agreed by the same and has filed the petition. The learned counsel for the petitioner has contended that prima facie no case is made out. The checks were given towards the security for the security. Not inclined to venture into the merits of the case at this stage. However, regarding head to the contention raised by the petitioner of the petition, I'm inclined to modify the impugn order, and the petitioner is directed to deposit 10% of the interim compensation, 10% of the check amount of interim compensation, and liberty is granted to the petitioner to move for application before the court below for variation of the order insofar as the remaining 10% of compensation is considered. At the same time, since the complaint case is pending since 2022, the trial court is directed to do well to see that the trial of the ICC case number 37 of 2022 is concluded as expeditiously as possible. With this observation, the petition is yes.
Item 10.
Your Lordship, I am appearing on behalf of Learned Counsel Sri Om Sarup, my Lord. I am seeking adjournment of 2 weeks, my lord, as my senior has undergone his surgery, eye surgery.
Copy for the petitioner. See, Om Sarup, to March last. Yes.
Item 11.
11 is Belgium matter, Lordship. The NBW order was issued on 15th 2024. Petition was released on bail on 16/8/2023, Lordship.
24,500.
15/3/24 NBW order था and bail order था 16/2023.
Yes.
Item 12.
Yes.
In this case, the petitioner who is accused in the
Yes, sir.
challenge the
Can you please use the mic? Yes.
My lord, the petitioner who is accused in the court below has challenged the cognizance order taken against him under section 138 of the NI Act.
Yes.
My lord, very highlighting point in this case, the complainant himself says in the complaint petition, page 12, at
Page 12.
page 12,
Okay.
para 8C, my lord.
Yes.
He says that he is having a excavator which was used by the accused,
The machine was engaged
my lord.
for
The
purpose of
machine was
taking-
engaged for the purpose of accused in the
Okay.
aforesaid site from 20th April 21 to 19 June 21 at the monthly rent
1
of
lakh. No.
1,70,000. That
Yes.
means 2 months for 3,40,000. And next he has said that the accused has paid 1,70,000. Then it will be, rest will be 1,70,000. But he has claimed 3,90,000, misutilizing the check which was previously.
No, no. What is the check amount?
My lord, the check amount is 3,90,000.
Yes, for 2 months.
2 months, 3,70,000.
20th April.
3 lakh. 2 months, 3,40,000, and he has
These
said.
are factual disputes. Why should I go into all these things?
My lord, the
Check. See, you
legal
have checked the issue.
legal debt and liability. The
That will be a factual dispute to be gone into in the trial only.
but the
You have issued the check or not? You show me your reply to the notice.
notice I have not received. He has stated might have been the impugned order. My lord may kindly see.
Let us see where that.
The impugned order says that in 1, 2, 3, 7, 8, 9, the notice might have been served to the accused, and there is no whisper in the impugned order.
No, no. Come to page 12.
I am reading, my lord.
H.
18.
Come to page. Forget about that. Come to the complaint. Copy of the complaint.
Complaint petition.
Yes.
My lord.
Complaint H.
My lord.
H.
My lord. The accused had received the notice on 1/6/2020.
Very specific about it.
My lord, my humble submission, he has not received. Even he did
You may
not.
be, but this is the
even,
contention.
my lord, even he did not
See,
receive
At
notice.
this stage, I need to see the complaint note. In the complaint, he is making very specific averment, saying that the accused has received the notice on 1st June 2022. And now onus is on him to prove it.
My lord,
If you dispute,
my lord, my
so
humble,
that will be done in the trial.
my lord, my humble submission. Let me accept that I have received the notice. But para 8C says it was used for 2 months, and he says what is the
These are
rate?
factual disputes, sir. I can't see.
No.
In a 138 case, I only have to see.
No, my lord,
check is issued by you or not.
it is not a money suit that I will claim set up.
No.
He has stated, my lord.
It is a summary proceeding, and I can
He
390 check.
himself, my lord, he himself has stated it was used for 2 months, 3,40,000.
That's not.
And how it will be 1
No,
3,90,000?
I don't know. For any other reason, also the check might have been given some expenses. So I don't know all these things. These are the facts.
No, specifically, he has stated the time use of the
That's
excavator.
right. You are right. Absolutely. You have to confront him when he comes to the witness box.
The prior facie, the Lord and Master would have seen what is my liability. This is the sign to a non
See 139.
138, my lord.
139 presumption operates against you the moment a check was issued by you.
My lord,
And a notice was given.
I admit that.
Notice has been received by you, specific government.
But that is subject to the averments made in the complaint petition, my lord. Unless there will be trial, my lord.
Okay, it's all right. I'll pass the order. I'll pass the order. Hard copy? Well,
Because, my lord, he cannot amend the complaint petition.
that you have to, sir. He has filed an affidavit also. You have to confront him in the witness box there when he comes.
And besides, I have paid excess amount for that money should be pending, I have paid.
So
Of
all
course,
these things are disputed question of fact. I can, you tell me what, beyond that, what else you want in this proceeding, which will help you, so that I can, you know.
my lord, I may be given scope to file a petition in the court below to reconsider the cognizance.
Okay.
To reconsider cognizance.
12. I'll just give that.
That I will highlight referring to the
yes.
amendments made in the complaint petition.
Petitioner is seeking, in this petition is challenging the order dated 13/9/2022, passed by learned S.D. James Hon'Ble in ICC case number 66 of 2022, whereby cognizance for offences punishable under section 138 has been taken against him. Counsel for the petitioner, by taking me to the development made in the complaint, particularly para 7 and para C, 8C and 8D contended that it is the admitted case of the complainant that the petitioner has used. What is that you have taken on rent? What have you taken rent?
Excavator.
Excavator, huh? Excavator from 20th April 2021 to 19th June 2021. The check is stated to be issued towards the rental for this period. At the rate of 1,70,000
per month.
However, the check amount is
3,90,000.
stated to be 3,90,000. It is apparent from the admitted stand taken by the complainant that the check is manipulated one. Therefore, the counsel for the petitioner submits that the trial court has not applied the judicial mind to while taking cognizance. I am not inclined to agree with the contention made by the petitioner at the stage of taking cognizance. Because the issue raised by the petitioner is primarily in this question of facts, which is a question of facts. The trial court has from a side taken a view that case under 138 has been made out against the petitioner. Hence, no interference is called for. However, liberty is granted to the petitioner to move specific application in this regard. If such application is moved, the same shall be considered on its own merit.
And he has also stated that I have paid 1,70,000.
But those things you can write.
He will reconsider and file application.
Or framing charge not a challenge.
Yes, sir.
Here I have challenged the order framing of charge, order dated 20/8/2024, passed by the learned SCST special judge. Your Lordship, the only ground is the petitioner is an old man of 65 years. And there was a civil dispute between the petitioner and the informant. Now, the informant, the prosecution allegation is on the 25 at about 7:30 p.m. without informant permission, the petitioner came over to the property.
Speak little louder.
Came over to the property and assaulted the informant, and the informant tried to prevent the accused person from entering into the residential premises. Thereafter, an FIR was lodged. So the police did not lodge the FIR. Thereafter, and 1cc case was filed by the informant, Your Lordship. After 1cc case, the police registered the FIR against the petitioner. Thereafter, the charge sheet has already been submitted, and the court taken cognizance to framing of the.
What is wrong in it?
So, there was a civil dispute between the petitioner and the informant. Your Lordship, kindly glance the page number.
Yes.
Your Lordship, page number 15, Your Lordship.
15, 15?
1515.
Yes.
Paragraph 7, Your Lordship. Page number 15, paragraph 7. Which is regard to the property dispute, Your Lordship. The accused created a scene which lasted for several hours and was witnessed by our entire neighbor. The sole person for that act to accused that we are living as a neighbor after having purchased some property in my
Little louder, sir, I second. Yes.
after having purchased some property in my brother name using our family fund, where they are accused without any nexus in blackmailing and trying to extort the newly purchased property from our family. So, Your Lordship, it's a complete civil dispute, and the civil suit number civil suit number
516 of the advice. Here, what happened? Here is a case arising out of a complaint case. Thereafter, under 156(3), law and master directed to the rest of the FIR. FIR has been registered, and 3 SCT is concerned. Other allies of IPC offenses, lots of there is. The whole contents of the my learned friend is saying that there is a civil dispute between the influenced brother and with the accused petition also. That is the main crux of the matter.
One of
That
the
there is
case is there against you. What to do?
360 is other allies offenses also there.
It is undoubtedly what I are saying is correct. It is all everything is arising out of a civil dispute. But this hangama has taken place. What to do?
only, so only in order to harass the
Because the
petitioner.
reason is that civil dispute. Civil dispute doesn't mean that you will create scene there and because of the
Only-
land dispute, all these things has happened.
Yes, my lord, but only in order to harass the petitioner, this case has been
Obviously,
firstly posted. And the framing,
yes.
Lordship, our prayer is to call for the LCR, admit the application, and call for the LCR
No,
from the lower court below.
You have to prima facie start. There is nothing in your case. It's not a routine thing that you file an application, then it will be, after all, charge has been framed.
Yes, sir. Also. That is important.
Unless you make out a case, how can I interfere? You tell me. Absolutely no case. Absolutely no. See, the statement you come to page 31, 31 onwards. What do you say? I'll just simply issue notice, let us see.
Arising out of complaint case.
Something may happen. I'll just issue notice. Issue notice. Because the allegations are very minor allegations.
Yes, sir. That's right, Your Lordship. But issue notice.
Why don't you settle the dispute?
We are trying to.
I'll just issue notice. Let us. Have you implemented?
OP, yes, Your Lordship. Yes. In front of OP2, Your Lordship.
Okay.
Page 2.
Issue notice. Yes.
Item 15.
Okay.
Okay, let it come one chapter left.
Item on request march.
It's a compromise made between the parties. They have mentioned in their ground number 5, 6, 7.
Let's say nahi, it's a
Nahi.
The compromise is
March.
Item 16.
16, this matter is going to be settled out of the court. You let it go 2 chapter.
Hey, what are the offenses?
Open 294, 332, it is converted 333 and 506.
Hey, where have you said that you have
34 IPC.
Where have you said that you have settled the dispute?
No, that in during penance of the there is a possibility. 2 chapter.
For the petitioner submits that during the pendency of the possession proceeding, the parties have entered into the settlement. The parties are yet to finalize the terms of settlement. Release the matter also. Short date.
And there is a possibility, my lord. There is a possibility because the talk is going on.
I've just written it. Otherwise, yes.
17.
Yes.
17.
17.
The cyber crime. The petitioner came before this court in the file a bail application. First bail application is rejected, therefore second bail application. Second bail application, there was the condition to deposit to 12 crore 80,000 rupees.
12 lakhs.
12 lakhs. 12 lakhs.
Okay.
80,000 rupees. But thereafter he has challenged the cognizance order.
Bail, he's
Bail granted.
granted. He's outside or
That information.
yes. Pass over Gauri. Yes.
18.
May I please, Your Lordship?
Yes.
Your Lordship, in this case, the petitioner have challenged the rejection of the discharge application of the magistrate, my lord. My lord, in this case, interestingly, the prosecution has launched this case against the petitioners on the report of one accused person who is an accused in another FIR arising out of the same transaction, my lord. My lord, I take your lord to that FIR, my lord, under Annexure 4, my lord, at page 59. The relevant page is item
Annexure 4.
page 62, my lord.
Yes.
And yes, ma'am. That informant is Vishnu Mohan Das, my lord, in this case, my lord. And in this page 62, my lord, may I read the facts, my lord? That the
62, huh?
Yes, my lord. Facts of the case, my lord.
Yes.
That the accused Vishnu Charan Das on 2nd July 2012 came to the residence of the complainant and persuaded him that he is the motivator of Seashore Group, Dhenkanal and Hon'Ble Multipurpose Cooperative Limited. And if money will be deposited through him, then per month interest will be paid on the deposits and many have availed this benefit. Many have availed this benefit. Even Mr. Vishnu Mohan Das said that there is no doubt in his integrity and he is not paying him by cash for deposit, but through check. My lord, after registration of this FIR as an arm twisting method, my lord, he has registered that the FIR in which the charge has been challenged, my lord, against the family members of the managing director of the Seashore Group.
Not only the complainant, the other 74.
Yes, my lord.
complainants were-
Yes, my lord. I take my lord to the 161 statement, my lord. At
I can't go into all these things. Let me see.
yes, my lord. My lord, there is no single investigation.
This has
There is
been,
no.
you know, this has been investigated by the CBI and all. I can't venture into all these things. Discharge.
No, no, my lord.
These are the cases.
These are the family members. I am
Maybe.
not the MD, my lord. My lord, there is no single iota of evidence
case
against.
is made out.
No, my lord, there is no case. My lord, if my lord, petition number 1 is the wife of the MD, my lord. My lord, I am serving as an assistant teacher, my lord.
Are you on bail?
Yes, my lord.
Yes.
My lord, may I take my lord to page number 49, 161 statement.
49?
49 of my lord, Mona Suwanso.
Okay.
टाउन थाना बाबू सम्मुखें आज 25 सुवंशो रिख दिबा मौखिक बयान एहिकि जे विष्णु मोहन दास कहवा अनुसार the informant persuaded the 73 others
Yes.
to take as a defense, like from escape from that. Yes, madam. अनुसार लिखित रिपोर्ट देलु गत 2007 मसीह ढेंकानाल गणेश बजार ठारे सीशोर कंपनी ढेंकानाल अनुगुल मल्टीपर्पज कोऑपरेटिव लिमिटेड बैंक खोली कार्यालय चालुला से प्रशांत दास, मनोज नाथ, ज्योतिराणी षडंगी, सुप्रभा दास, शांतिप्रभा दास, प्रभात कुमार दास लोक मान सभा समिति एकाकू कराई मासकू 2% और वर्ष को 24% सुध हिसाब से जमाट टंका 2 वर्ष 3 वर्ष 2 गुणा करवा यही संगे टंका आदाय कर आसुले प्राय 10-15 कोटी टंका आदाय करी कुआडे ऑफिस रे ताला पकाई पळे गले समस्त गरीब लोकंकर टंका नहीं कोठा बाड़ी गाड़ी सुना किणी अयस करूछंती एणु एही धारे समस्त प्राय 74 जनक टंका हड़प करी ठकी धरी जाइछन
74 numbers.
Yes, my lord. My lord, neither I have conducted any meeting, my lord. My lord, neither I have been involved in any of the transaction of the
How will
company.
they go into all these things at this
My lord,
stage?
my lord, may kindly see the brief facts of the affair, my lord. What investigation has been done by the prosecution?
I will not read the FIR and decide the case at this thing.
My lord, no charge has been made out against me, my lord.
Then you argue that those things. Yes.
My lord, I will satisfy your lordship.
I am already satisfied.
No, my lord.
No, further satisfaction is not required. 74 people you have taken money and.
My lord, I have not taken, my lord.
No.
My lord, the prosecution has not investigated about the company, my lord.
I am not going to touch. Don't waste your time. Better I will, any other relief you want from this, you tell me.
I'll try to.
My lord, give me some time, my lord. I
No,
will
no.
satisfy your lordship, my lord. But the prosecution has not investigated the company also, my lord. Against whom, against the company, the informants have been made the
You
allegations.
need further investigation. I'll pass that order.
No, my lord.
Then
But-
these are court cases. Why are you keeping all this? I'll expedite the trial if you want. You tell me what best relief you can take, except discharge. You tell me, if it is suits us,
My lord,
I'll pass it over. Huh? You just tell me.
my lord,
What best relief you can take from this proceeding? You think over that.
my lord,
Don't waste your energy for discharge. You think over what best relief you can take from this proceeding. I'll give that. Think over. Pass it over.
no, my lord, kindly give me some time, my lord. I'll satisfy, sir.
Tomorrow. Sometime in tomorrow. Monday.
My lord, but they,
No,
IAF,
I'll not keep it pending. I'll just, because you are requesting, you just read it.
my lord, that adjournment.
Nothing. I'm going to dismiss it, sir. Monday you come and tell me what best relief you can get from this proceeding.
Yes.
Except discharge. Okay? Monday.
19.
We withdrawn this case.
Tell the dates.
The date of bail 10th April 2014 and the LBW is the 2nd April 2024.
Okay. 500.
Why not withdrawn this case? Withdraw, he wants to. Yesterday forwarded to court of law.
You want to withdraw?
Yes.
Okay.
Why not withdraw?
Give a memo.
Yes, sir.
Send a memo.
Okay. I will.
Yes.
Item 20.
This case is arises out of 1cc case number 69 of 2023.
Yes.
Pending in the court of JMFC Pipili, offense under section 494. That without any document, the complainant filed this case.
Yes.
Petitioner, present petitioner is the husband of the complainant, opposite party number 2. At first, the OP number 2 initiate a proceeding against the present petitioner before the police station Pipili, and the same is sent to the Brajarajnagar police station for investigation. But Brajarajnagar police station has not get any clue regarding the 494. Thereafter, close the case.
What kind of document you need?
I need myself is the petitioner. Without any document regarding the marriage of the second marriage, the OP number 2 initiate the case.
She is making allegation.
These
kind of, for every marriage you need not have any document. You might have married in the temple also. Who knows?
Till the disposal of the divorce case, I have paying the interim maintenance.
That is not the issue here. Issue here is taking cognizance.
Taking cognizance.
The allegations are there.
Allegations.
That you entered into second marriage and all. That has to be proved.
No, only the oral statement of the
marriages are, if first marriage is in existence, you are entering into the second marriage. Obviously, you will not create any document for that. You might have gone to the temple and married.
No. I'm not gone.
No, yes will not help you, sir. You have to tell justify. That is what her allegations are. It has to be tested in the trial only.
May I pray? My learned friend's client, the petitioner has already filed a divorce petition that was allowed in page 30.
That's right. That's a different story. That's it.
Notice may be issued.
Bigamy and all. I'll issue family. I'll issue notice. Just check it out. If you can settle. No state. Don't tell me. I am not satisfied. But I am issuing notice only because it is a matrimonial dispute kind of thing. If you are already divorced and settle, you want to stay with this lady.
No.
Obviously, you want to stay with this lady.
Already divorce is allowed.
We'll see. Issue notice. Yes,
Myself is staying at Jharsuguda.
We'll see. Yes.
Court is Pipili.
20.
21.
Yes. 21.
May please. Discuss my lord.
petitioner seeks to challenge the order of cognizance dated 15/12/2017, my lord. And that cognizance taken under section 302 and other allied offences, my lord. The dispute regarding, my lord, two villages, my lord. Construction of the house, my lord, in a river embankment, my lord, the river belt. And it is alleged that on the date of occurrence, two villages, my lord, when the deceased persons weren't there, my lord, the accused persons assaulted them by means of deadly weapons, my lord. No specific allegation against any of the accused persons, my lord. Charge sheet submitted against 14 persons, including the present petitioner, showing the petitioner as absconder, my lord. In the meantime, my lord, I kindly annexure, my lord. You're not on bail. Not on bail, my lord. Annexure 4, my lord. Judgment 3 of the co-accused persons faced the trial, my lord. They have been acquitted on the ground, my lord, as in paragraph, my lord, 30 and page 61, my lord. Paragraph 30. If permitted, I read out, my lord. 30. Page 61. Judgment, my lord, 31. Yes. In view of the such quality of evidence and a procedure adopted by the investigating officer is to be tested by if two accused persons facing the trial conspired with the others accused persons and frame unlawful assembly intending to commit murder of Kartika on dated 21/1/13 village Fulpali during scrutiny of the evidence in connection with the offence under 149, 120B IPC. I have already stated above. Prosecution majority failed to substantiate the regarding any criminal conspiracy or common interest.
So what are the allegations against you?
Against common against, my lord, allegations, my lord, charge sheet can see, my lord, page 39. My lord, common manner, my lord, charge sheet submitted. All the accused persons may conspire between them and unlawful forming unlawful assembly asserted this. That is the allegation, my lord. And if in that, my lord, charge sheet, my lord, this petitioner and shown as absconder.
See, but the problem is 2013 the FIR.
My lord.
Charge sheet was filed when?
17, my lord.
17.
My lord.
You have been absconding.
My lord.
Now in 2016, some judgment is passed in so far as the co-accused is concerned.
My lord.
You want to take advantage of it.
Not that, my lord. That happened, my lord, the direct decision of our own High Court, my lord. In another case, my lord, could not make 2012, my lord. Second part 2 OLR 961, my lord. That case, my lord, similar rule also taken since co-accused persons acquitted. The prosecution majority.
You under the aid of 120B and 149, you
exactly.
You have been roped in.
My lord.
And there is a judicial determination now 149, 120B is not made out.
My lord. 302 also not made out against the co-accused persons.
It doesn't say that.
My lord, the next paragraph, my lord.
Yes.
30. Paragraph 31, my lord. As regards to offence murder, it is also already observed above. Prosecution failed to prove
which
para 31, my lord, page 61.
61.
Failed to prove the offence 302 of IPC by adducing inconsistent evidence of the villagers through the evidence on under Section 27 Evidence Act. The evidence of the chance witness.
You are entitled to bail.
But when again, my lord, face the trial, my lord. But in fact,
you are. I am giving you indication. You are entitled to bail. That's all. Beyond that, you have to face the trial.
Yes. Observe.
Because there is a specific finding that 149 is not made out, 120 is not made out, 302 is not made out. But we are absconding what to do.
Yes. But a direct decision of our own High Court, they have the
decision. Right now, petitioner.
Relying some decision of Supreme Court.
What are you seeking here?
Question of cognizance.
Right. Where is that cognizance?
Cognizance, page 11.
11.
Annexure 1. Relevant person.
How many of you are there?
My lord, total 14 accused persons, my lord. 3 face the trial, they have been acquitted, my lord. Others against others absconder. All others are absconder, my lord.
What are you doing for living?
But the petitioner was in the outside, my lord. Not in this.
I'm just asking, what are you doing for
business? Small business. Doing business in
you pay cost. Because 2000 cognizance order is which year? 2017. Right. Petitioner one of the things in FIR number 24. The ACIT was filed after investigation in the present case on 28/10/2017 for alleged commission of offences punishable under section 147/148/307/302/120B/149 IPC. Subsequent thereto, the petitioner was shown as an abscond in the charge sheet. Subsequent thereto, on 12/2017, the court below taken cognizance of the offences as mentioned above. Next, the petitioner is assailing the said conviction order at which the advocate speaks on the ground that three of the accused persons, those who have faced trial, have already been acquitted by the Court of Additional Sessions, Bhubaneswar, in Sessions ST, case number 109 of 2014. 2014. By judgment dated
13 July 2016.
But I'm just see page 20.
Judgment.
Page 20. The charge sheet is filed on 28/10/2017. And how the trial started in 2014.
The co-appeal was also arrested by 13 manner. They have faced the trial.
But no, that's right. The charge sheet, just see the charge sheet. In this case, page 20, if you have annexed. This is the only charge sheet filed. You see the date. 28/10/2017.
2011.
See the date.
This is the final charge sheet, madam. This is the final charge sheet.
What about the charge sheet for the other accused person?
That is not, my lord, here, my lord. Perhaps, my lord, they might file the preliminary charge sheet against the they have faced
Then you have to tell me though, how will I write them?
that is, my lord.
If I write the charge sheet is filed on 17.
Initial charge sheet is not there in name, my lord. Final charge sheet,
Show me that.
That is not with me, my lord. Passport.
I'll just pass it over. Otherwise, how will I write the current charge sheet?
Two more, my lord. Two more, my lord. Better.
Tomorrow.
Okay.
You give me date chart. When the preliminary charge sheet was filed, what those people do? Here's the trial. Because their trial started in 14.
Exactly. Since these petitions are absconded, for that is a final charge sheet sounded.
Subsequently, I think on 17.
I'll verify. I'll verify.
Just give the.
Two more.
I think in this charge sheet, there is a mention after investigation he submitted the final form 43 dated 2013
against the Cognizance.
Babula Jena.
Where charge sheet, my lord? Charge sheet. Charge sheet.
Page 39. Page 39. That is charge sheet.
Charge sheet is preliminary charge sheet. It will better, my lord, to dispose of.
1 minute.
After investigation, he
1 minute, sir. 1 minute, sir. 1 minute.
Fourth paragraph.
Fourth paragraph.
Okay.
But the dates have been mentioned in different.
When the preliminary charge sheet is filed?
16/5/2013.
One of the accused.
After investigation, although the preliminary charges for the other accused persons were filed on what is the date? 16?
1 thing, my lord. As to accuse, my lord, Babula against us 16/5/2023. ତାପରେ another co-accused, my lord, against us 6/10/2013. ଆଉ ଜଣରେ 21/10/2013 ତିନି ଥର ଫାଇଲ ହେଇଛି।
ସେଥିରେ ଲେଖା ହେଇଛି ଏମାନେ abscond ରେ ଅଛନ୍ତି।
Insofar as the present petitioner is concerned, he has been shown as a abscond. The final charge sheet dated 28/10/2007. Mr. Ragada, let him counsel for the petitioner relying upon the para 61, na?
Page 61, paragraph 30 and 31.
31.
And also 32.
31, 32.
30, 31, 30.
Rely upon para 31, 32. So the 31 para 30.
30, 31, 32.
30 and 31. About the judgment of the additional sessions judge Bhubaneswar dated 13/7/2016. Mr. Ragada contends that insofar as the co-accused persons are concerned, there will be a judicial determination that no case, the prosecution could not prove the case under either under section 149 or 120 IPC. Since the present petitioner has been implicated in the present case under the aid of section 149 and for the charges under 120B, read with section 302, 302, subjecting the present petitioner to trial is destined to be a futile exercise. Therefore, he seeks the indulgence of this court that you seek question for the cognizant order for him. I am not inclined to entertain this petition at this belated stage. Needless to say that the evidence, needless to say, the acquittal order passed by the additional season says who are the accused persons are the culmination of appreciation of evidence which has come on record vis-a-vis the accused persons also face the trial. But at the same time, the observation made by the court while recording the acquittal assume importance insofar as the present petition is concerned. Although the concern, in view of the observations, the petitioner may be entitled for grant of bail, but we can inevitable on his part to face the trial. Therefore, although I am not inclined to entertain the present petition, I direct the petitioner to appear before the court on or before of 15th of January and face the trial. Since in view of the observation made by the learned additional sessions judge Bhubaneswar in ST case number 24 also, the petitioner is entitled to grant of bail. Since the matter is pertaining to an FIR registered in 2013, it is expected that the trial courts shall do well to see that the trial is concluded.
Yes.
22.
May it please your lordship. My lord, item number 22, similar matter your lordship heard previously. It is relating to 64 number of rescued cattle, my lord. The police handed over the rescued cattle in our Gosala.
There is an order very similar.
CR.
Let us see his notice.
And stay on the further proceeding.
Where is that order? Have I passed the stay order in that case?
In CRLMC number 4780, I will supply the copy. 4780 of 2024.
4780 of 2024. 24 is the same order. Same order.
Along with again, same area case, same Gosala. Same Gosala is the petitioner in both the matters.
Let it come, both the matters should come in same day?
Yes,
same order? Same order, same. Okay.
The matter is fixed to 31st January 2025.
Okay.
Great.
Yes.
23.
My plea, my lords. My lord, against the rejection of a recall petition, that is Annexure 7, my lord. And this is my lord. Grievous offense, my lord, 363, 376, and POSCO Act and the SCST Act, my lord. Prosecution, my lord, during trial, my lord. The himself Annexure 6, my lord, special prosecutor and the trial court, he filed this 311 petition before the court below that recall of the PW 1, 2, and 6 is necessary for the best. But that petition has been rejected, my lord. PW.
Them come.
My lord?
Who are you?
My lord?
Who are you? You are.
I am the informant. I am the father of the victim, girl, my lord. The POSCO Act and
right, but the prosecution is not coming. I'm challenging. I'll issue notice. See, because you moved an application which is turned down. And he's agreed being informant and coming. And what is your stand? You just see, I'll just issue.
And extra 6, my lord, the special.
I issue notice.
My lord.
Short date I'm giving.
I stay, my lord, because it is going to my lord.
Why are you are the informant, why are you trying to say?
But the acquittal lord, it's going to my lord, they are going to pass the acquittal order, my lord, because the Hon'Ble, the trial court saying, my lord, Hon'Ble High Court given target to dispose of the 14 cases per each month, my lord.
Show me there.
My lord, that is your lordship, my lord.
Show me the implement.
That's the operating portion of the rejection.
Very way, that is what I'm asking. Where is that?
Page 30, your lordship.
30, yes. What does it?
Because when acquittal that is a very urgent matter, therefore, your lordships. Your lordships, my lord, allow the 311 petition, and my lord, one chance may be given to recall that petition. So that it will be.
Without hearing accused, I will not do that. Because particularly when the prosecutor has not.
That they have filed this case, my lord, taking the importance of the case. Otherwise, trial will come there.
What is the stage now?
Now the trial is going to cover 4 accused persons, my lord. There are total witnesses, my lord, 4 out of my lord. They have to examine vital victim, mother, and father. All.
Issue notice next week. Next week. Yes.
Date fixed in the lordship.
Next week. Fix it date.
Again, can't go trial.
I know because many witnesses are there.
My
Don't
lord.
worry about it.
Somebody I can't my lord. This is for practical field, my lord.
I'm just issuing notice. I'm keeping it next week because they should come forward and tell.
Again. Out of court kouchi. Khali vital survey gale tole gote survey doji, my lord. Out darkar na mane out of exam koru na thi.
Next week.
My lord.
Next.
Apply.
24. This is a case of fraud of rupees 2 crore and 30 lakhs.
Who are you?
I am not yet imputed as an accused.
Then why are you coming?
Why I am coming? But some amount have been transferred to my account of the nursing home.
You need a preemptory order.
I need my lord, what I need my. The police is pressing that you have to pay the amount which you have taken. But during investigation, I have come and I am ready to pay the amount.
How can I do all this? You are not an accused.
I am not an accused. I am apprehending because of the some amount. They will see my how the account have been.
But see, on the basis of apprehension, can the 482 court pass an order?
Yes, yes.
Oh, how can I pass the order? It is only 438 court. If you have a problem, you go and.
482,
No, but you see, these are only theoretical things. But if you are not an accused, I don't know whether you will be accused or not. I'll interfere. Then I'll prevent them not to investigate against you.
No, investigation to कौन सी court में नहीं बाबा.
So what are you asking, Justice?
I am asking, my lord. I am asking that I am ready to pay the amount which have been determined, which will be determined by the court. Let them say what is the amount involved.
This is not my job. 482 court job.
But it is relating to liberty of a person.
Liberty is person 438 you file. That liberty I am giving you. As it is, you have a statutory liberty, but you can go and file. This is a petition, a 438 petition in disguise. You are not even an accused today. You want quashing of an FIR.
Na, mu quashing na duni.
Let's see.
Aapun dekho mu place. Mu ekate kan quash.
This is what you are asking basically.
No. I am not asking to question.
The prayer is no coercive action. Coercive action.
Coercive action.
How?
So that I can pay the amount.
If you are not an accused, where is the question of coercive action? I don't understand. You yourself say. Apprehending for that, sir, madam, apprehending 438.
Why?
But then you are interested that I should be a negotiator.
No.
You will pay this, you do that, all these things. I will be the negotiator here.
Every day the police is calling me to the
That I can't stop.
It's not a harassment, my lord. When you have not made me an accused, every day you will call me to the police station and coerce me to pay the amount. That's why I am 482 I have filed.
Cyber crime, what I can't do. What best I can give you, tell me, in this petition.
Let them take instruction, my lord. Only thing I will let them.
See, I'll tell you, this will create problem for you in the sense, once you file this petition, they have not made you accused, now they will make you. The moment I issue notice, I am telling you, this is going to happen. They have not made you accused so far. The moment I issue notice, next day they'll come and say that you are an accused. Why are you inviting all this? You tell me what best I can give you.
Well, let them take instruction.
I have to issue notice. Then trouble will be there for you. If you want, I can issue notice. Issue notice next week. They'll come and tell that you have been an accused. This is bound to happen. I know that. Okay, so that. Okay, you want to be an accused. So far, they have not made you an accused. They will make you accused. The moment I issue notice. And you know, vast experience you have on this. Okay.
But everyone why they are coming.
Okay.
But they have already arrested the principal.
Okay, issue notice get inside. Status report to no. No. I'll just see that if he's not accused, don't do anything. Give instruction to the IO. Okay? Give instruction to the IO. If he is not an accused, don't
take any action.
Yes. Next. Yes. Next.
25.
In this case, the complaint case is initiated against the present petitioner who is
205.
my lord, who is 3 times MLA. This complaint case is initiated.
138.
No, 420, 466, 468. Allegation is that this petitioner is 3 times MLA, ex-MLA of BJD government. While during filing of nomination paper, allegation is he has filed a matriculation certificate where date of birth is not matching. That is the allegation only, my lord. Or other things. Those
Your application under
205 that has been rejected. Relying upon a decision of Allahabad High Court, my lord.
All right, I'll issue notice. Issue notice. As a politician, why should politicians are entitled to do this? Unless issue.
My lord, there's no courage to accept it.
What force you action?
My lord, ଯଦି ମୁଁ appear ନ କଲେ 6 ତାରିଖ ହେଉଛି ଡେଟ୍ ଟା NBW issue ହେଇଯିବ।
Can you serve him? Tomorrow I'll pass the order and finish it up.
As your lordship please expert ଯାଉ notice ସେଇ order ଟା ହେଇଗଲେ ମୁଁ ସେଭ୍ ହେଇଯିବି 15 ଦିନ ଯାଉ ମାସ ଯାଉ ଯେବେ ହେଲେ ବି ହେଇପାରିବ।
Issue notice written also. In the meantime, petitioner is given liberty to move application for seeking adjournment. So seeking adjournment for court will move an application. And it is made clear that on the next week appearing, the present petitions shall be disposed. Video, who to week for it.
May I pray one thing? Your lordship may fix a date so that we can be disposed of.
That's what I'm saying. I'm giving a date. File process fee immediately. Requisites. If you don't file requisites, then
no, I will definitely, my lord, I will do it tomorrow. My lord, that adjournment I will file. It will be
26.
May I please, your lordship? My lords, this is an appeal against judgment of conviction, my lords.
Sentence?
Substantive sentence, 3 years.
Okay,
In the connected appeal, my lords.
Connected
Appeal, lordship call for PCR and
Das is appearing for the vigilance.
bail was granted and the fine was.
Yes, bail granted.
My lord, 5 appellants in this common CRLA. In this CRLA, 5 accused appellants are there. Number 1. Number 2, your lordship has already admitted on 20th of December.
I know. He has already given that order. I'll tag with that.
CRLA 1293 may be listed along with this appeal because it is 1278.
That's what he said. That's what he said.
Right.
May be listed along with this.
Yes.
And free copy of the order be given. Obliged.
27.
What about the
Lordship, may kindly have a glance at page 12 and 30. Lordship, there are 29 accused persons before the lower court And in this present year, you see only 10 have approached to the learned.
All right, they will pay when the NBW was issued.
NBW was issued on
23rd.
25.
All of them were on bail.
No specific date has been mentioned.
Do you have the dates? They were on bail for there. They are on bail. NBW. And if you have date, give it. And NBW was issued on
20.
which police station is this?
It was CJN ASJ Nuapada.
Nuapada. 500 each. Is Nuapada. Nuapada district court. 500 each. Oh. 20th January. APF. Okay. 500 each. 7 also.
NBW was issued on 30/9/2019.
28, huh?
20.
Yes. 28. NBW.
In 30/9/2019.
Bail.
Bail is not pending.
Bail on bail कर दियो ताकि भी शेयर कर दियो ठीक है 500
29
May please, Your Lordship. It's a Belgium matter, my lord.
Yes.
The petitioner was released on bail on 15/4/2008 and subsequently in the year 2012 on 2/8/2012 NBW has been issued, my lord.
You have to give little more.
My lord.
2000. Which bar you want to give? Kotak.
My lord, Banki, SDGM Banki, my lord.
Banki, SDGM. But there is a bar there, Banki bar.
Yes, my lord.
Banki bar, huh? Bar Association Banki, 2000.
May I suggest 1,000, my lord?
No, I have intended to do. You are appearing, it should be 5,000. 2012, what are you? You give it to your bar people.
My lord.
Yes.
Obliged, Your Lord.
30
NBW was issued. NBW was issued in this case that was filed under section 138 of NI Act.
Tell me the dates.
25/4/2024.
Lordship, in this case 205 application has been allowed.
It's all right. 500, huh? 500.
31
Belgium matter lordship, bail was granted on 27/5/2022. NBW issued on 15/9/2023.
23, okay, 500. How many of you are there? 500. Yes.
32
Please, Lord. There is a Belgium matter, my lord. NBW issue on 28/11/2019, my lord. The present petition was bail on 22/5/2017, my lord, in pursuance to order of Honorable Court, my lord.
500, Punjab.
My lord.
Punjab.
33
NBW was issued on 4/6/2024. Bail was granted on 3/3/2012.
500. Yes.
34
Wait, please, Your Lordship. Ma'am, bail granted on 1/8/2024. NBW issued on 9/10/2024.
500.
35
35, my lord.
NBW release on bail 13/3/2024. NBW is 7/12/2020.
500. 500.
Obliged.
Thank you.
Let's in this case, the petitioner challenges the order dated 21/4/2022.
Yes.
By which the petitioner was directed to pay interim compensation amounting 20% of the check amount under section 143 of NI Act. Let's, while deciding the interim compensation, London trial court has not assigned any reason with regards to the quantum of compensation. And the petitioner also, the complainant, failed to make out a prima facie case.
Yes.
That's the impugned order is at page 15.
12,60,000 rupees.
Let's compensation. 2,52,000. 20% of the check amount.
You simply tell whether you have issued the check or not.
No, let's. I have also denied in my objection.
Where is that objection?
Objection is at page 26, annexure 3.
26.
Let's.
Annexure 3. No, not objection. You show me the reply to the legal notice.
But I have not received the pleader notice.
In the objection, what objection is not required. Objection is not contemplated under the procedure.
I have filed the objection under section 143A of NI Act. To that petition, I have filed objection.
All are disputed facts.
Learned trial court also held that the objection raised by the accused person are matter of facts to be proved by his in the trial. He has also not taken into consideration my objection.
Where have you said that you have not received the notice? In the objection. You have not said that. In the objection, where have you said that you have not received the notice?
Let's. I have also mentioned that it is not a fact that the check in question was issued by
No, that is a different thing. You 138 statutory notice reply. To talk about that.
Well, since I have
come to page 22, and para 11 and K and L he is very specifically said, and relying upon the postal receipt also, and track report also he has filed. K and L.
22.
Track report he has filed, postal receipt he has filed. Then you
23 page.
You accepted received the notice. You didn't reply. Then you should have told all these things. The presumption operates against you. I will not interfere.
Let's the accused has not prima facie.
Prima facie, I made out the case. Complaint. Just see the complaint.
With regard to the quantum of compensation, Supreme Court also, Honorable Supreme Court also, in case of Rakesh Ranjan Srivastava versus State of Jharkhand, also laid down the broad parameters for exercising the discretion under section 143A. It's specifically directed that
it says that it's not mandatory, it is directed.
Discretionary.
That's right.
If Learned trial court,
what is wrong in exercising discretion?
Learned trial court has allowed 20% of interim compensation.
I'll make it 10% move on application. Same right. Petitioner is agreed by the order dated 21/4/2022 passed by Leonard James Kotak in ICC case number 184 of 2020, whereby
the petitioner has been directed to deposit 20% of 20% compensation, 20% of the check amount as interim compensation, under section 143, capital A of NIA. Land counsel for the petitioner has pointed out from the impugn order that although pointed out that the trial court has not supported the direction with sufficient reason. He has also taken me to the objection filed by the petitioner to the application under section 143, capital A, moved by the opposite party. I pay perusal of the application, complaint, and the objection filed by the petitioner. It is clearly reveals that the petitioner has not replied to the statutory notice under section 138 NIA. The opposite party has very categorically conceded in the application in para K and L, para 8K and L, para 8K and L, that the statutory notice under 138 NIA was issued to the petitioner, and in that regard, the postal receipt and track report has been placed on record. Since the petitioner has not replied to the statutory notice under 138 NIA, the presumption under section 139 NIA operates against him. Therefore, in that view of the matter, I'm not inclined to this petition. But, however, taking into consideration the reasons taken in the application, I'm inclined to reduce the interim compensation to 10% of the check amount, and grant liberty to the petitioner to move fresh application before the court below for variation of the remaining 10% of the compensation amount. If such application is moved, it will be considered also.
That's my only one para. Let the presumption under section 130, Honorable Supreme Court also in the said judgment held that the presumption under section 139 of NI Act by itself is no ground to direct the payment of interim compensation. My only prayer is that the learned court will be directed to consider my objection and take a lawful decision with regard to the quantum.
That I have said.
Yes. Fresh decision in accordance with the taking into consideration.
I have reduced to 10%. 10% you have to deposit in any case, and for the remaining 10% you move our case. Yes.
Item 17 is another matter. The other person the options are fixed to 10th of January. So I pray that this matter may be called
10th January.
10th January.
Which matter?
I'm also appearing in that.
Leave to
Leave me.